Good morning. If I could, please, I'm dedicating this video to the person who asked this question right here, person named Mo, 83444. And of course, Mo was talking to me. Mo had asked the question, what exactly are you referring to? Please and thank you. The state constitution would supersede such law. Now, now, this question Mo had asked me came from a video that was done, which was by a TikTok account, American Paper Trail. And anyway, in this video, the TikTok account, American Paper Trail, was talking about the Constitution of the United States being the supreme law of the whole country, which is true. It's true, very much so. Now, I posted a question in that video that said this. Well, first of all, let me back up, please. Just as we have the United States Constitution, which is the supreme law of the whole United States, east to west coast, each state in the United States has its own state constitution, which is supposed to be the supreme law of that state. Now, I posted a question to American Paper Trail, and I said this: what about a state making a statutory law that conflicts and contradicts its own state constitution? And then, of course, that's when then Mo here said, and yes, I'm actually rereading it again. Mo said, what exactly are you referring to? Please and thank you. The state constitution would supersede such law. I posted a comment underneath Mo here, and I told Mo I told him he was right. Yes, he's right. A state constitution. In fact, if I could, please, according to the Federalist number 78, Alexander Hamilton. If you don't know who Alexander Hamilton is, Alexander Hamilton's face is found on the front of a $10 United States bill. That is, $10 bill. Anyhow, Alexander Hamilton said this. He said, and I quote, "No legislative act, therefore, contrary to the Constitution can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance," here we go, conflicting and contradiction. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred. Or, in other words, the Constitution ought to be preferred to the statutes. Now, unquote. Now, that being said, I cannot speak for every other state in the United States, just only my state of South Carolina. On a previous TikTok account of mine, one of my earlier videos in the TikTok account, I mentioned about the confliction and also contradiction between the Constitution of South Carolina and also the statutory laws in South Carolina. And the Attorney General's office keeps wanting to bring it up. And yet, though, let's see. Yeah, I want to read this to you now. Listen carefully. This says, and I quote, "The framers of the U.S. Constitution made it supreme law of the land, but they left unanswered the question of who was to sustain the supremacy. In the Philadelphia Convention debates of 1787, James Madison, the father of the Constitution, declared that," he said, quote, "a law violating a constitution established by the people themselves would be considered by the judges as null and void. Accordingly, James Wilson, Oliver Ellsworth, and John Marshall, all destined for appointment to the U.S. Supreme Court, subscribed to the doctrine of judicial review in their respective ratifying conventions. On January 17, 1788, Oliver Ellsworth of Connecticut declared, 'If the United States go beyond their powers, if they make a law which the Constitution does not authorize, it is void, and the judicial power, the national judges, who, to secure their impartiality, are to be made independent, will declare it to be made void.' On the other hand, if the states go beyond their limits, here we go now, talking about South Carolina and possibly other states as well. On the other hand, if the states go beyond their limits, if they make a law which is an usurpation, which means to undermine, usurp means to undermine. Upon the general government, the law is void, and upright independent judges will declare it so. So therefore, this right here now, I want to show this to you, which I know to be factual and true. In 1895, South Carolina came out with a constitutional amendment referring to the age of consent. This is a carbon copy of the South Carolina Constitution. You can see right there where it says South Carolina Constitution, right there. And then, of course, right down here is this right here, pertaining to that. Now, this is Article 3, Section 33 of the South Carolina Constitution. If you try to look it up online, you won't find it. You won't find it. Why? Because the Attorney General's Office of South Carolina had it taken down. You try to look it up, it will say removed for revision. Because the State Attorney General's Office of South Carolina, they don't want the public to know about this right here. But anyhow, this copy came from a 2003 cumulative supplement that was given to me. Right here. 2003 cumulative supplement. So that says right there. Code of Laws of South Carolina, 1976. And see where it says right there, Volume 21, Constitutions. Now that being said, the problem is that, I'm going to put this other page up right here. The problem is that, as I said, back in 1895, the General Assembly of South Carolina, the state lawmakers that is, they made this constitutional law pertaining to age of consent, which says, and I quote right here, Article 3, Section 33, it says, and I quote, no unmarried woman shall legally consent to sexual intercourse who shall not have attained the age of 14 years. That's right. But yet, in 1976, they came out with a statutory law almost 100 years later that said this right here. A person is guilty of criminal sexual conduct in the second degree if the actor engages in sexual battery with a victim who is 14 years of age or less, but who is at least 11 years of age. In other words, I did some research and I found out that the state of South Carolina has been illegally locking people up for what the Constitution says is legal. Do I think it's right? What I think doesn't matter. It's what the Constitution says, okay? It's what the Constitution says. So, Mo, hope that this answers your question. Thank you very much and have a blessed day.